I have little respect for your opinion because I've read your stuff. When someone is in the White House that you agree with and someone gets a universal injunction against him, you don't like universal injunctions. You called them judges acting like they're politicians in robes and judges looking like crass political actors. But now that President Trump's in the White House, who you dislike, you think that universal injunctions taste like pumpkin pie. So I have to discount what you say because I think you act on your political beliefs. And I worry that that's what you're teaching your kids. So I'll leave you out of that. Do you think nationwide injunctions are being abused?
Certainly, Senator. I think that is.
They're being abused by both sides, aren't they?
Yes, Senator.
Both Republicans and Democrats are forum shopping, aren't they?
Certainly.
Professor, do you disagree with that?
I think both sides are abusing them. I agree.
Okay.
Bold truth. Senator John Kennedy steps into the spotlight and refuses to let double standards slide in this explosive hearing on nationwide injunctions. In a moment that quickly turned intense, Kennedy takes control of the room with sharp, relentless questioning, cutting through vague answers, and forcing clarity where others might settle for ambiguity. His message is clear: the rule of law must remain consistent, regardless of who holds power or which side benefits. As the discussion unfolds, Kennedy zeroes in on what many Americans have been questioning for years. Are nationwide injunctions being used as neutral legal tools, or have they become strategic weapons in political battles? Instead of allowing the conversation to drift into abstract theory, he brings it back to principle, pointing out how positions seem to shift depending on whether the White House is held by someone favored or opposed. Kennedy challenges legal experts directly, highlighting past statements and contrasting them with current positions, exposing what he argues is a pattern of selective reasoning. Take a look.
Professor, let me ask you this while I have you. On April 22nd, 2024, you said there are some members of the Supreme Court that are evil. Which justices were you talking about?
I'll take it your word, Senator. I don't recall using that word, but.
All right, here's what you said. You were talking about the majority opinion in Muldrow v. City of St. Louis. You said, quote, Justice Kagan, will she be able to control the opinion's future distortion by her evil colleagues? Probably not, end quote. Who were you talking about?
Sir, I'm very skeptical. If it's a transcription, it was probably a transcription error. I do not think I said.
No, you said it. Why don't you own up to it? Which you call some of the members of the Supreme Court evil. Now, which ones do you think are evil?
I would have to refresh my recollection. I've been very critical of some members of the Supreme Court.
You made that statement, aren't you?
I'm
You're an officer
Senator, it doesn't sound like something that I would say.
You know what I'm embarrassed at? That you're teaching our kids.
I don't refer to Supreme Court justices as evil in the classroom,
on
sir.
On your podcast, April 22nd, 2024.
Okay, well,
big as Dallas. And you're an officer of the court, and you're here advising us to be respectful to federal judges, and you say they're evil members of the United States Supreme Court? Gag me with a spoon. You're part of what's the problem in all of this. Both sides. Yeah. There are no clean hands here. Now, your suggestion is that when a federal judge issues a nationwide injunction, there should be an automatic stay and an expedited right of appeal. Is that right?
Yes, sir.
Do you disagree with that?
I haven't given enough thought to have a position on it, Senator.
I suspect, Professor, your answer will be it depends on who's president.
No, Senator.
Let me ask you about this. What if we had a rule? I was reading an article the other day. I'm not suggesting it. I just want your opinions. That said, if a president, any president, issues an executive order, let's say, that clearly violates settled Supreme Court precedent that a federal judge can't issue a nationwide injunction. For example, if a president issued an order that said no one in America has right to counsel any longer, including but not limited to, in a felony case, having the government pay for your lawyer if you can't afford it. That clearly violates settled Gideon v. Wainwright. In that case, a judge has no authority or does have authority to issue a nationwide injunction. But in a case where the law is unclear, a judge should refrain from that. Now, obviously, we'd have to trust our judges, but we're supposed to be able to trust them anyway. What do you think about that?
I don't agree with that, Senator, because I think universal injunctions transgress the limitations under Article 3, even if the underlying merits are clear.
I happen to agree with you. I don't think there's any basis under Article 3, under Supreme Court precedent, under the English common law for nationwide injunctions. I think politicians have helped judges, and many judges are politicians, to just make it up. And many of them are like Professor Shaw here. If they like the president, they're against nationwide injunctions. If they don't like the president, they're for him.
As the hearing comes to an end, the intensity may settle, but the impact of what just happened doesn't fade. Senator Kennedy didn't simply participate in a routine exchange. He reshaped the entire tone of the conversation by refusing to accept ambiguity where clarity was needed most. In a setting where answers are often carefully crafted and softened, he chose precision over politeness, pressing until contradictions became visible, and forcing responses that could no longer hide behind legal jargon. His approach sent a clear signal: accountability is not optional, and neither is consistency. At the heart of his argument was something bigger than the moment itself. It wasn't just about nationwide injunctions or controversial statements. It was about the foundation of trust in the legal system. Kennedy made it clear that when principles appear to shift depending on who holds power, people begin to question whether justice is truly being applied fairly, and once that doubt takes hold, it becomes difficult to restore confidence. Supporters will see his performance as a necessary pushback against what they view as a growing pattern of selective reasoning, a reminder that the law cannot operate on preference or political alignment, that it must remain steady, predictable, and grounded in principle, even when it's inconvenient, especially when it's inconvenient. What stood out most was his willingness to confront uncomfortable issues directly. He didn't avoid tension, he leaned into it, whether addressing the idea of defying court orders in rare cases, or challenging remarks about the Supreme Court. He kept bringing the discussion back to one central idea: standards must be applied evenly, without exception. There's also a broader message in his approach. In a time when public trust in institutions is constantly being tested, moments like this resonate far beyond the room. They shape how people perceive fairness, authority, and the balance of power. Kennedy's stance reflects a belief that restoring confidence begins with demanding transparency and rejecting double standards wherever they appear. Even for those who may disagree with his tone or his conclusions, it's difficult to ignore the underlying point he continued to drive home. The rule of law must not bend to political convenience. It must stand firm, regardless of who benefits or who is challenged by it. And that's ultimately what gives this moment its weight. It wasn't just a political clash, it was a statement about what kind of system people want to believe in. One where rules are applied equally, where leaders are held to the same standards, and where the pursuit of justice is not influenced by shifting loyalty.